Sure. Thank you. Well, I'm glad everybody has been able to join us today. I know it looks like, based on the names on the boxes, I know several of you, so I'm glad to see that and that you have joined us again today for some education from Anthony Enea. For those who don't know me, I'm Mark Podolsky, and I'm pleased to serve as your host today. I am PACE's Director of Planned Giving, and in that role, I work with many of PACE's alumni and friends who have included PACE in their future estate plans or might have questions about including PACE, either with a will or a trust, perhaps a retirement plan or a life insurance policy. There are nearly 400 people, actually, who have left an estate gift for PACE, and they are recognized in our Edward Mortola Legacy Society. And during Anthony's presentation today, he will briefly touch on some charitable giving as part of an estate plan. So if any of you are interested in learning more about PACE's Edward Mortola Legacy Society, I am glad to have a follow-up discussion in coming weeks. Before we start, I have a few housekeeping tips for today's meeting. Your microphone was muted upon entry, and we ask that you remain muted to avoid any disruptions. If you have questions during the presentation, please enter them in the chat box at the bottom of the screen, and Anthony will address as many questions as he can following the presentation. Please also note that we are recording this session, and it will be posted on the PACE website shortly. So now, it's my pleasure to introduce our speaker, Anthony Enea. Anthony is a 1985 graduate of PACE's School of Law, which is now our Elizabeth Haub School of Law. He is the managing attorney of Enea, Scanlon, and Sirignano, LLP of White Plains, New York, where he focuses his practice on wills and trusts, estates, and elder law. Anthony is the past chair of the Elder Law and Special Needs section of the New York State Bar Association, and he's also the past chair of the 50+ section of the New York State Bar Association. He is a past president and founding member of the New York chapter of the National Academy of Elder Law Attorneys. Anthony is also the immediate past president of the Westchester County Bar Foundation and a past president of the Westchester County Bar Association. So Anthony, welcome, and thank you for your presentation today.
Thank you, Mark. Thank you again for having me, and thank you to the Elizabeth Haub School of Law for doing this for their alumni and anybody that's interested in the program. So today we're going to talk about the critical estate planning issues that are facing everyone, right? So everybody has different situations and circumstances. People have different size estates. People have estates that are very large and have issues vis-a-vis estate taxes. Then there are people that have more modest estates that have issues with respect to how can they afford to pay for their long-term care in the event, they need either nursing home care or home care when they have, modest means. They don't have millions and millions of dollars. And what happens to the surviving spouse if that spouse is going to remain in the community and now the other spouse has gone into the nursing home or needed care at home, and that's significantly expensive and it's going to cost a lot of money? How does that drain the family of their resources? And we'll talk about, again, at the very end, we're going to spend some time talk about charitable giving. I think it was very nice of Mark to mention the Mortola Foundation and the fund that they have for the school. I think that's an excellent idea to mention that. So let's start off what the objectives are today. So our objectives are going to be, we're going to learn about healthcare proxies, HIPAA forms, living wills, and durable powers of attorney, all very important documents. If anybody is, at this session, each one of us should have these documents. We're going to understand the ramifications of having a will and what happens if you pass away and you don't have a will. Then we're going to talk about various strategies that could be used to avoid probate, including the use of irrevocable and irrevocable trust. And we're going to talk about a last will and testament. Obviously, that is always, even if you have a revocable or irrevocable trust, a last will is always a centerpiece of the estate planning. And finally, we're going to get into Medicaid eligibility and what steps you can take to protect and preserve your assets in the event you need Medicaid in the future. How can you limit the extent of your exposure to the cost of long-term care? So let's start off with the basics. We've got a healthcare proxy, power of attorney, living will, HIPAA form, and a burial designation form. Then we have a last will and testament, revocable trust, and irrevocable trust. What's a healthcare proxy? Well, a healthcare proxy is recognized by law in New York. There is a statute that creates the healthcare proxy, and it allows you to make an appointment of an individual to make decisions for you when you can no longer make those decisions for yourself. So if you're unable to make decisions, you can select somebody to be your healthcare agent. However, you can only select one person at a time. You cannot have co-agents on the healthcare proxy. That's the first thing you need to remember. The second thing is, who are you going to select? Are they going to be immediate family members, spouse, children, etc.? And what are your wishes vis-a-vis your health care if you're no longer able to make decisions for yourself anymore? So if I can no longer decide about my health care, I should tell the person that I've selected to be the agent what my wishes are. I should specify for them that I don't want nasogastric tubal feeding. I don't want to be on a ventilator if that's what my wishes are. And under the circumstances that you don't want the nasogastric tubal feeding or the ventilator, you should be able to identify the circumstances, because there may be circumstances that you want the ventilator or nasogastric tubal feeding, but there may be circumstances that you don't. It really comes into play significantly when we're talking about end-of-life decision-making. The healthcare proxy is very important there because generally that's the stage where the person is not competent anymore to make decisions, and they need somebody to be able to be their voice and to express their wishes and desires to the medical people that are taking care of them, the hospital, the doctors, etc. So you have to be careful in who you choose, because if you choose somebody that's very close to you and emotionally tied to you, well, they may not be willing to fulfill your wishes. So you really want somebody that's going to be a family member, obviously, but maybe not as tied in to your wishes in the sense that they're going to be so sympathetic to keep you alive and want to keep you alive that they're not following your wishes. Okay, so every adult should have a healthcare proxy. It's a very important document, and again, it's legally recognized, has to be signed, dated, and it requires 2 witnesses, and you can name an agent and an alternate agent, and you should tell your agent what your wishes are, right? And that's something that you should do. You should explain to them, when you want to be removed from life support. That's something that's important. What is a HIPAA form? Well, the HIPAA form, excuse me, is an authorization for release of health information pursuant to HIPAA. And HIPAA is the Health Insurance Portability and Accountability Act of 1996. What this document does, and by the way, in the healthcare proxy, there is a HIPAA authorization. There is built in, there's built in to the healthcare proxy a HIPAA authorization. But what we do in our office, we do an actually separate HIPAA form. The HIPAA form allows you not only to pick the person that will have access to your medical, doctor, and hospital records, but the actual form has categories of medical records that you can select that you want your agent to have access to. For example, psychiatric records, alcohol and drug abuse records, HIV/AIDS records. So we like to do this separate form, which is much more specific and also allows for the records to be identified, the nature of the type of records. Okay. Excuse me. Living will. Very important document, but it's not a document that's recognized by law in New York. It basically has a statement in it that says the following: if I'm brain dead, comatose, with no hope of recovery, I don't want to be kept alive by extraordinary measures. So even though there's no law that recognizes the living will, it's really like a belt and suspenders approach with the healthcare proxy. Healthcare proxy says, I nominate so-and-so to be my agent. And I've told my agent what my wishes are. And obviously in a healthcare proxy, you can also specify what your wishes are. You can be very specific about the care you want and don't want. We don't recommend that in a healthcare proxy. We don't recommend that you be very specific because that kind of ties the hands of the agent. We would prefer that the agent know what your wishes are and you've explained that, because the actual document says my agent knows what my wishes are unless stated herein. So the living will is basically a way of saying, hey, I told what my agent my wishes were. He knows what my agent wishes are. And by the way, I'm stating if I am brain dead, comatose, with no hope of recovery, I don't want to be kept alive by extraordinary measures. So we always do a living will as part of the package of the documents that we prepare for our clients. They always get the HIPAA form, the healthcare proxy, and the living will. So the living will is, like I like to say, it's the belt and suspenders approach, and it's something like you keep in your back pocket. You don't give to the medical providers the living will if you have a healthcare proxy, because the healthcare proxy should be sufficient. However, if there is an issue that comes up about keeping you alive and using, mechanical means to keep you alive, and you do have the living will, well, then your healthcare agent can pull that out to the medical provider and say, hey, not only did they sign a healthcare proxy, they signed a living will. And that living will says that they don't want to be kept alive by extraordinary measures if they're brain dead, comatose, with no hope of recovery. And hopefully none of us ever have to go through that situation where their family has to make that kind of decision. But it does happen. It does happen. And unfortunately, especially with seniors that are very ill, it could happen on a regular basis. Durable power of attorney. Let's talk about the different types of powers of attorney before we get to durable, okay? So there are different types of powers of attorney. There's a general power of attorney, right? And the general power of attorney is good until you become incapacitated, right? It doesn't survive your subsequent incapacity. The durable power of attorney is the power of attorney that survives your subsequent incapacity. So you can sign it, have it fully executed, and the next day you can become incapacitated. You had a heart attack, you had a stroke, and now your agent can use the power of attorney. It's durable. It survives your subsequent incapacity. You can also have a springing power of attorney, which is something we don't recommend. We don't recommend springing powers of attorney because we think they're dangerous. Why are they dangerous? Because in a springing power of attorney, you have to identify the event that you want the power of attorney to become effective when it happens. So you could say, this power of attorney is a springing power of attorney, and it doesn't become effective until 2 of my treating physicians have certified that I'm no longer competent to make my financial decisions. Okay, so that could be the springing event. But with anything that you write, there's a problem with interpreting those documents. So whenever you have a condition that you specify for the power of attorney to become effective, well, then you could be dealing with the situation that two people can disagree as to whether that springing event occurred or didn't occur. So we don't do springing powers of attorney. We do durable general power of attorney. You appoint somebody, your agent, to be able to handle your financial affairs. The power of attorney is effective the moment you sign it. It's not effective down the road. It's a valid power of attorney from the moment signed, witnessed, notarized. The question becomes, are you going to give your agent the power of attorney? Are you going to deliver the power of attorney to your agent so that they can handle your financial affairs? I would tell you that I would say 90 to 95% of the clients, they don't want the power of attorney delivered. They want us to hold on to the original, and they say, and they agree that we're not going to turn over the power of attorney to anybody unless we get their consent. If they can provide the consent, and if they can no longer provide the consent, then the power of attorney will have to be released upon receipt of a letter from a doctor that says that the principal is no longer able to make financial decisions. So that's what we rely on to release the power of attorney, is a letter from a doctor. So generally, clients don't like to give it to the agent because depending on how broadly the power of attorney was drafted, that power of attorney could allow for unlimited gifting of assets, transfers of assets from the principal to the agent, creating a trust, revoking a trust. So the power of attorney is a document that's very, very important. And basically, it is prepared in accordance with the wishes of the principal. You need to elicit, as an attorney, from the principal what their wishes are. How broadly do they want this power of attorney to be drafted, or they want a power of attorney that is a general durable power of attorney, but doesn't have all the gifting powers and all the powers that would go into the modification section. So power of attorney allows the agent, if they have the power of attorney, to handle, the basic transactions, real estate transactions, banking transactions, okay? But you can give the agent broader powers, and you can customize the extent of the powers that you want the agent to have. So you look at the general provisions of a power of attorney, you'll see real estate transactions, banking transactions, business operations. Those are the standard powers. One of the standard powers that's very interesting is all other matters. A lot of people don't realize that the all other matters power of a power of attorney allows the agent to create a revocable living trust for the principal and to fund the revocable living trust. And that sometimes very much so comes in very handy if we're doing Medicaid planning and we don't want to create a 5-year look back period. And we don't want, for example, somebody to die with probate assets. So having this power to, in all other matters being checked off, allows the agent to create a revocable living trust and to fund it. But the other standard powers are like real estate, buy and sell real estate, banking transactions, going to the bank, writing checks, making deposits, right? Making withdrawals to pay the expenses and bills of the principal. Then if there's a business involved, the principal was a shareholder or an officer of a corporation, there are business transactions that could be done, estate transactions, litigation. A power of attorney allows the agent to commence litigation, to defend litigation. And the power of attorney has now also been broadened to allow the agent to get involved in healthcare billing matters for the principal, where they can question the hospital, the doctors about their billing practices and the insurance, et cetera. So tax matters always included. And then I went through with you the all other matters. Now, if you want to enhance the power of attorney and make it a broader power of attorney, that's where you're going to do the work in the modification sections, right? The modification section is where you're going to basically enhance the power of attorney. I call it, super energize it. That's where all the powers are now given that are not traditional standard powers given to an agent under a power of attorney. Gifting. You can make gifting as broad or as strict as you want. If you want to have unlimited gifting power, you want your agent to do all of the possible gifting you could do, then you give them broad gifting power where they can gift to themselves, your children, your grandchildren, etc. They can create trust, prepare revocable and irrevocable trust, have access to your safe deposit box, hire attorneys, hire accountants, hire somebody to provide care to you, enter into personal service contracts, make statutory elections, right of election, do a disclaimer, do a renunciation. These are all various statutory elections. If the individual needs Medicaid planning, the agent can be the person that's given the power to sign the spousal refusal form on behalf of that principal who is the spouse of somebody that needs to go into a nursing home, but they're not competent. Also, in the power of attorney, we put in a lot of language about digital assets and digital devices, because more and more of our clients, right, are having assets that are on the internet. They have digital bank accounts. They have, Facebook accounts, and giving people your agent access to those accounts becomes very important, especially if you have, Bitcoin and other types of cyber, currencies. Those are things that you have to, be cognizant of when you're drafting the power of attorney for the client. The other thing you have to understand under the new power of attorney form, there's finally been given some really teeth to the idea that if the principal has an agent and the agent delivers the power of attorney to a third party, and the third party refuses to act under that power of attorney, they have refused to accept and acknowledge the power of attorney and do what the agent is requesting. Now this third party has basically a certain period of time to either accept or reject the power of attorney. They just can't dilly-dally anymore. The banks, the financial institutions can't dilly-dally. There's a period of time that's set in the statute, and they basically have to either accept or reject the power of attorney. And if they reject it, now it allows the agent under the power of attorney to seek, sanctions and penalties for them if they believe that the power of attorney was not properly accepted. Okay? Last will and testament. Everybody should have a will. If you're 18 years of age and older, you should have a will. What does a will do? A will is a writing that's signed at the end thereof. It's dated and witnessed. And in a will, you can specify who you want the beneficiaries of your estate to be, what percentages you want them to get, what dollar amounts you want them to get. You can have provisions in a will that are specific bequest. You can have a provision that's a specific devise of real estate. You could say, I give, devise, and bequeath my real property and improvements located at 245 Main Street, White Plains, New York, to Mark Potulsky. I just gave you the building, Mark, okay? That's a specific devise of real property. So you can do that. You can make these specific bequests and devices, but you have to understand something about a will. And I think especially lawyers that don't practice wills, trusts, and estates, they kind of lose sight of this. A last will and testament only controls assets that are in your name alone on date of death. It does not control assets that are in joint bank accounts, accounts that have TOD on them, in trust for accounts, life insurance policies that have named beneficiaries, IRAs, 401ks. Anything that has a named beneficiary is not controlled by your last will and testament. That's controlled by the document, and that property transfers by operation of law to the beneficiary. In addition to being able to specify who's going to get your estate in a will, right? You can appoint the person that you want to be the executor of your last will and testament. So in a will, you nominate either an individual or a bank or financial institution to be the executor of your estate. You can have co-executors. You can have a trustee for any trust that you're creating in the will, right? The will does not have to have a trust in it, but you can create a trust in the will. You can say, I give everything to my children surviving outright in equal shares per stirpes. However, if any of my children are not surviving, I want their share to go to their issue in equal shares per stirpes. However, if their issue are under the age of 25, 30, whatever age you want to pick, or you can say a lifetime trust, you can create a lifetime trust, then you will have a trust in your will, and that's called a testamentary trust for the benefit of those beneficiaries who are not going to get the assets outright. Okay? And so the will has to include certain things. It has to include the named beneficiaries, people, entities, pets, right? You can have a pet trust. You can have a provision in your will that creates a trust for the benefit of your pets. You could say, I want X number of dollars of my estate to be held in a trust for my pets, so and so and so and so. And I name this individual to be the individual that's going to take possession of my pets and who's going to receive the money from the pet trust for the care and maintenance of my pets for the remainder of their life. Okay? So you can have charities that are beneficiaries in the will. You can have the Elizabeth Haub School of Law at Pace University. You can have any charity that you want, and there are advantages if you're to your estate if you're going to name a charity, and we'll talk about that a little later. You can have specific bequest of tangible personal property. You can identify specific items of personal property that you want to go to individuals. However, you have to understand something. If you do a will when you're 60 years of age and you say, I want my Rolex Yachtmaster to go to Michelle Camardella, right? Now she's going to get that Rolex Yachtmaster. Well, that presumes that when I die, the Rolex Yachtmaster is still around. A, that I didn't give it to somebody else. B, I didn't sell it. Or C, I didn't lose it, right? When you identify something in your will as going to an individual, there are assumptions being made that this item is going to exist when you pass away. So you have to be careful of that, because sometimes what will happen is, and I see this with seniors all the time, is they'll say, I want my daughter to get my Rolex Yachtmaster, but, right, when they die, the Rolex Yachtmaster is not there. We can't find it. It's not within the personal property. It turns out that the individual gave the Rolex to a grandchild. So it's not there. And now there become questions. Did the grandchild take the Rolex Yachtmaster? When was this gift made, etc.? So I'm not big in putting in a lot of specific tangible personal property bequests in a will. I think they just create a lot of confusion, and they do something else. Well, whenever you have specific tangible personal property identified in the will, you're going to need to go out and appraise it, because it's going to be includable in the taxable estate. So if we can avoid that, what I try to tell clients is, you're better off if you just give it to the person that you want to have it while you're alive, and you tell your family, this is who you gave your Rolex to, or the Steinway piano to, etc. So you can make specific bequest of tangible personal property. You can make a specific devise of real property. Understand something with the devise of real property. If you do that, if the property exists and the beneficiary is alive on the date of your death, that specific devise vests automatically upon the death of the testator. The will doesn't have to go into probate for the individual to be vested with that specific devise of real property. That it vests on the date of death of the testator. And again, in the will, you want to have the residuary estate. That's the catch-all that says, if on my death, the rest, residue, and remainder of my property goes to the following named individuals. That's the catch-all. You have the specific bequest, could be cash, money, tangible personal property. You can have a specific devise, and then you have the rest residue. And again, you name executors or an executor, and you name the trustees. The other things that you can do in the will, you can express your wish as to whom you want to be the guardian of any of your minor children. You can also express wishes as to how taxes are to be paid from your estate and who is going to share in those taxes. For example, you could say that my residuary estate shall pass without apportionment of taxes, or you could say with apportionment of taxes. So again, you can make the decision as to how the taxes are going to be allocated. For example, people that are getting specific bequests, they usually do not share in the taxes because they're not getting the residuary estate. They're getting a specific bequest. You can also have information in your will about IRAs and how the IRA should be treated. And if there's a trust for a beneficiary of an IRA, how that should be treated for tax purposes. Obviously, a no contest clause is something you want in every will. You don't want somebody to easily be able to challenge your will and hold up your estate. So you want to make it clear that if you're going to challenge the will and you lose, that you're not going to get your bequest. You're not going to get your share of the estate. And usually wills also have simultaneous death clauses in them as well. What happens if you die without a will? Well, if you die without a will, you die intestate. And if you die intestate, right, you don't get to pick who is going to be the administrator of your estate, and you don't get to pick who's going to be the beneficiary of your estate. That's going to be determined by the laws of intestacy, right? So SCPA 1001 gives you a hierarchy of the individuals who can obtain letters of administration from the court, and EPTL 4-1.1 provides for the distribution of an intestate decedent's property. So it's a big problem if you die without a will. And the advantage of having a will is, A, you get to pick who your beneficiaries are, the amounts they get, the percentages they get, any items that you want them to get, and you get to select who you want to be the executor and trustees of your will. But if you have no will and you die intestate, you lose that. And now there is a pecking order of who's going to receive the property. Did you die with a spouse and no children? Then everything goes to the spouse. If you died with a spouse and children, then 50% goes to the spouse, 50% goes to the kids. If you died with no spouse, no descent, no children, but you have parents, so then the money goes to your parents, then it goes to your siblings. You've now lost the ability to control and designate who you want to be your beneficiaries. So, for example, if you haven't spoken to a sibling in years and you die without a will and all you're survived by are your siblings, guess what? That sibling that you haven't talked to in years can apply to be the administrator of your estate, and that sibling is going to get a part of your estate, right? So that's what happens when, obviously a will has to go through probate. That's an expense. It's time consuming, right? You have to hire a lawyer to go through probate in most instances. The fees can be a percentage of the size of the estate, and there are delays in probate. There are things that have to be done during the probate process. There's documents that have to be filed with the court, inventory of assets, affidavit of completion. And a probate proceeding, when you have a will and assets in your name alone, can easily go from 9 months to a year from beginning to end. In some of the counties in the city, it could be even longer. Brooklyn, Kings County, Queens County, Bronx County, it can be a longer process because the courts are inundated with the estates of decedents, and the process of probate from beginning to end can take longer. It could take longer for the executor to be appointed and to be able to marshal the assets and pay the expenses and make the distributions. A lot of the problems with probate or dying intestate are resolved if you have a revocable living trust. So a revocable living trust is a trust that's created by the grantor, the person creating the trust. And in New York, the grantor can also be the sole trustee. As long as there are alternate beneficiaries, in New York, you can have a revocable living trust. You can be the sole grantor and the sole beneficiary. And then you have alternate beneficiaries or contingent beneficiaries when you die. What is the big advantage of having a revocable trust? The avoidance of probate. In a revocable trust, you can do all the same estate tax planning that you can do in a will. In a will, you can do a credit shelter trust. You could do a disclaimer trust. Whatever tax planning you can do in a will, you can do the same in a revocable trust. The key to having a revocable trust that is going to work is that you take and retitle the assets when you create the revocable trust in the name of the trust. So your bank accounts would be in the name of the trust, not your IRAs, because your IRAs have named beneficiaries and should have also contingent beneficiaries. But every bank account you have, every brokerage account should be in the name of the revocable living trust, right? The real estate, generally the attorney will deed your house to the revocable trust so that the house is owned by the trust. When you do that, you should make sure that the insurance on the house names the trust as the owner of the property and the beneficiary of the insurance. They have to be the primary insured. The big advantage is when you die, there's no probate. The assets in the trust, the alternate trustees will step in, make the distributions of the assets, first marshal the assets, make sure that all the assets are in the trust, pay the expenses, any funeral bills, any medical bills, if there are estate taxes, pay the estate taxes, and then make the distributions, right? So if you have all of your assets in a revocable living trust, then when you die, there's not going to be probate. The transfer of assets to the beneficiary happens really quickly. I just had a client die a few months ago, and she had a revocable trust. She had her house in it and $200,000. She had two kids. They didn't want to sell the house. We deeded the house, the trustees, which were the two kids, deeded the house to themselves as equal tenants in common, and they took the money and divided it after they paid the expenses. Literally, the trust was wrapped up and completed within, I would say, 6 to 8 weeks after the death of the decedent. In a probate, you wouldn't even get letters testamentary in 6 to 8 weeks. You probably haven't even filed the probate petition at that point in time. But with a revocable trust, you can wrap up an estate, especially if it's an estate that has no tax issues, rather quickly. The other advantage of a revocable trust is that if, for example, you become incapacitated, right, before your death, the alternate trustees can step in and they can handle your financial affairs, right? They can step in, present a letter from a doctor to the bank or to the brokerage firm and say, Mr. Smith is no longer competent to act as trustee, and we are the alternate trustees. Now they can continue to manage your assets. Okay. So again, avoidance of probate, very helpful during disability, can do all the estate tax planning that a will does. So frankly, for many of our clients, we like to make the revocable trust the centerpiece of the estate plan. If you're concerned about the cost of long-term care, and I would say that in Westchester County, other than the 1%ers, virtually all of us should be concerned about the cost of long-term care. As you're aging, you have to worry about how much it's going to cost to stay at home and get care at home, especially if you don't have long-term care insurance. I mean, obviously, if you have long-term care insurance, you have a buffer, you have a dollar amount that's coming to you from the policy that can be used for either home care or nursing home care. But if you don't have long-term care insurance and you have savings, and those savings disqualify you from Medicaid, then you have to really start worrying about the cost of care. Nursing homes in Westchester are running anywhere between 180,000 to 210,000 per year. They're much more expensive in New York City, Long Island, a little less expensive in Connecticut, New Jersey. The cost of home care has really shot up. I'm now hearing from my clients that through an agency, they're paying $35 an hour for the cost of care. And when you do that $35 an hour based on a 24/7 caregiving arrangement, it's costing almost as much as the nursing home care, between $180,000 to $200,000 a year. So if you're getting 8 hours of care and you're paying $25 to $30 an hour, you're still going to be spending about $87,000 on your care. So very expensive. It siphons away savings from the seniors, right? And if there's a husband and wife, it makes the pool of money available to the senior, the surviving senior, a lot less. So the question becomes, what can you do? What steps can you take now to protect your assets in the event that you need long-term care in the future? Well, the step that you can take is that you can create an irrevocable Medicaid asset protection trust, right? This is an irrevocable trust. In order to protect assets, it has to be irrevocable. It cannot be revocable, right? It's a defective grantor trust. What does that mean? It means that it's set up in such a way that it complies with the grantor trust rules, but it's defective in the sense that it's not a completed gift for gift and estate tax purposes. And the way we do that is by reserving certain powers to the creator of the trust. One of the powers that we reserve to the creator is the power to change their mind by exercising a limited power of appointment as to who the ultimate beneficiaries are going to be. So you create this trust and you take your assets and you transfer them to the trust. And you don't take all of your assets, but one of the assets that's commonly transferred to the trust is an irrevocable, the house. The house is typically transferred to the trust, and also maybe some of your savings, not all of your savings, because nobody wants to give up all of their savings and not have control over their money. So if you have a client, let's say hypothetically, that has an $800,000 to $1 million house in Westchester County, they're over 70 years of age, they have $500,000 in savings. Typically, they would put the house in the trust and maybe part of the $500,000 of non-IRA savings. You should know that for Medicaid purposes, Medicaid does not count the face value of an IRA. However, if you're receiving Medicaid benefits, they force you to take your required minimum distribution. And also, you have to make sure on an IRA that you have named beneficiaries and alternates. Because if you have an IRA and you've gotten Medicaid benefits and you die and your beneficiary is not surviving and you don't have an alternate, then that money is going to go to your estate. And in New York, Medicaid has claims and liens on all probate assets. So what is an irrevocable trust? It's a trust and it's non-probate when you die, right? But you transfer assets to it, you are disqualifying yourself for Medicaid. So if I'm 70 years old, I'm going to disqualify myself for 5 years from getting nursing home Medicaid. But if I'm in good health, that shouldn't be a problem. So the longer you wait to do the trust, the greater the possibility that you may need Medicaid nursing home within the 5-year look back period. In 2020, in October of 2020, Medicaid passed a 30-month look back period for home care Medicaid. They have not implemented that 30-month look back period yet. So right now, if you give assets away outright or to an irrevocable trust, you are not disqualifying yourself for Medicaid home care. There is no look back period now. So if you have a senior, a parent, a friend, and they're struggling because they need care at home, they can transfer their assets out of their name and get Medicaid home care. They will look at your income, but there are ways of looking at protecting the income. When you transfer the assets to the trust, the Medicaid trust, you cannot be the trustee. So you have somebody else as the trustee. Typically, parents name their children as the trustees. The individuals creating the trust cannot receive any of the principal of the trust. So if I put money in, I can't get that money from the trust. However, if you put your house in the trust, you have the right to live in the house for the rest of your life. Nobody can sell it or rent it without your permission. You pay all of your bills just like you're paying now. You get the STAR exemption. You get the veterans exemption. You get any senior citizens exemptions you're entitled to. I think I said you get STAR. STAR is a very big exemption. The other thing that you get, because the trust is not a completed gift, and for income tax purposes, you're deemed the owner of the assets in the trust, you also get the personal residence exclusion. If the house is sold, you can exclude $500,000 from capital gains if you're married and $250,000 from capital gains if you're single. However, if the house is sold, the proceeds of sale from the house have to be held in the trust, right? So the proceeds of sale come in back into the trust, and now the trust can go buy you another place to live in. The biggest detriment to the trust is that you basically don't have access to the principal. That's the largest detriment. However, there's a way to get around that. And the way we get around that is by creating what's called a backdoor. We give the trustees the power to go into the trust and give principal and income to each other. So let's say I put $300,000 in the trust and put my house in the trust. And I kept $300,000 in my name or in a revocable trust. And during my life, I used up that $300,000 that I had control over. I used it up and it's gone. And now I need money for repairs to the house, or I need money because Medicaid's not giving me round the clock care for home care. Well, the trustees can go into the trust, give income and principal to each other, deposit the money in their own bank account, and then they can give it back to mom or dad or use it for mom and dad's needs. So that's the back door. There's no tax consequence to the individual gifting or giving the money back unless, right, they're making gifts of more than $17,000 per year, right? If there's only one trustee, they can only give 17 per year to their parents. So that's 34 if there's a husband and wife. But if they're married, their spouse can join in the gift, and that's another 34. And if you have multiple children, they can do the same thing. So it's a great vehicle for protecting assets and giving the parents peace of mind that they still can live in the house, that nobody can just go take the money out of the trust. Because even though the trustees can invade principal for each other, we don't give them the power to invade for themselves, right? They can only invade for their siblings or their children, but not for themselves, right? So we avoid that, okay? Excuse me. The other problems with it is that the transfer is a taxable gift of a future interest. There is no annual exclusion available when you put money in the trust, right? Also, if you're reserving a limited power of appointment in the trust, you're reserving the right to change your mind as to who the ultimate beneficiaries can be. Well, by reserving that power of appointment, the gift is incomplete. So this is not a device that's used for estate tax planning where you're making a completed gift. It's an incomplete gift. But the advantage of having it as an incomplete gift is that when the creators of the trust die, the assets in the trust come back into their taxable estate, and the beneficiaries get a step up in the cost basis. The beneficiaries get the assets in the trust at fair market value on date of death of the grantor of the trust. They get a step up in the basis. Very advantageous. It's just like inheriting it under a will or getting the property under a revocable trust. The key with using the Medicaid trust is that you want to use it when you don't need Medicaid and you're in good health, right? You don't want to wait until you're 85 and been diagnosed with Parkinson's or Alzheimer's to do it, because now the risk of you needing nursing home Medicaid within the 5 years becomes higher. So you really want to do this kind of planning when you're younger, and in good health.
Anthony, I just want to be conscious of the time. It's 12:50.
Yeah. So we're
Okay.
going to now cover naming charitable entities as a beneficiary, right? So you can name a charitable entity as a beneficiary on a bank account, a brokerage account, a retirement account. You know, you can have either one charity, you can have multiple charities. That's a very good way of giving, money to charity. You don't have to do it in your will. Generally, you have to understand that if you have charitable entities in your will and they're getting a percentage of your estate, then that will and has to be on notice to the Attorney General's office of the state of New York. So if I were to say in my will, I give 10% of my estate to the Elizabeth Haupt School of Law, right? Then the Attorney General is going to be brought in to determine how that 10% is calculated. They're going to be reviewing the accounting of the executors of the estate. They're going to want an accounting of by the executor. So that's something that you have to understand if you're going to give a percentage of your estate to a charitable entity. If you do it in an account, then it passes outside of probate and it goes automatically to that charitable entity. For example, let's say you don't have other ones surviving other than a child. You have one child who's single and never going to have any children. Well, on that IRA, you may say, I name my child as the beneficiary. However, that child's not surviving, I give it to a charity. You can also do that with retirement accounts, and using a charitable beneficiary for a retirement account is actually quite advantageous. And we're going to talk a little bit about doing that. Okay. The only disadvantage for the charity is when you have them named on the account is they're only going to get what's left in the account at the time of your death, right? They're not going to get, if you had an IRA and you started off with $1 million in the IRA and you lived 30 years and you were taking the IRA down, drawing it down for the last 30 years, well, you may not have a lot of money left, but it's still going to go to the charity. So that's an important thing to remember. Maximizing retirement accounts. You have a 401k, you have an IRA, or you have a qualified annuity. Using that for plan giving is a very good option. And the reason why it's a good option is because of the loss of the stretch for people other than your spouse. So if I were to die, and for example, I had no surviving spouse, and now my IRA is going to go to my children, unlike in the past, because of the Secure Act, under the Secure Act, they have basically three options. They can take the IRA out on my the year of my death. They can withdraw it in 10 equal installments for 10 years after my death, or they can do it in the 10th year. So there is no longer a lifetime stretch for somebody that's not your spouse as a beneficiary. Another way of avoiding potential estate taxes is you can name a charitable beneficiary on your IRA, right? So when you die, right, the charity receives the IRA. You also get a deduction because it's a charitable gift. It's a deduction against the size of your estate, right? If you have a Roth IRA, that's a different situation. With Roth IRAs or Roth retirement accounts, when the funds go from your retirement account are withdrawn, they're going to lead to income taxation if it's not a Roth, right? So if any other regular IRA leads to income taxation. So especially post Secure Act, with the lifetime stretch being gone for non-qualified beneficiaries, most retirement accounts are going to end up losing up to 1/3 of their value, if not more, to income taxes, right? So that's something you have to keep in mind. If you're over 72 years of age, soon to be 73, and are required to take your minimum distributions from your retirement account, you're also able to donate up to $100,000 per year without those funds being considered taxable distribution to you. So let's say, for example, I have a relatively large IRA, right? And I don't need all the income from this IRA. And I know if I take it all, I'm going to be paying income taxes at my rate. And my rate combined federal and New York is, 40 something percent. I may think it'd be much more wiser to not pay the income tax and donate up to $100,000 per year from that IRA without those funds being considered a taxable distribution. So the benefit of doing that is twofold. First being that this will lower the donor's adjusted gross income. And the second is that the charitable entity is receiving the funds and they will not need to pay income tax on the funds. In effect, the funds from your retirement account have completely and forever avoided income tax. That is a big advantage because one of the biggest problems that seniors, including myself, are going to face in the years to come is that when we start taking our minimum distribution, we're going to have to pay income taxes on that money, which is actually going to basically, draw away. So if I have a $1 million IRA and it's going to give me $33,000 a year, let's use that as the number of my minimum distribution. Well, that $33,000 is going to be taxed. And depending on my tax rate, it could be close to 45% of that money that's going to income tax. And if I have a charitable entity that I have a fondness for, it may be much better to utilize that charitable entity as the beneficiary of it. Okay? Same thing with if you name the charitable entity as the beneficiary of the retirement account on death. If the full value of your retirement account goes to the charitable entity, that entity will not pay income tax on the funds received, and you in turn will never have paid income tax on it. Further, if you're at risk of having a taxable estate, you wouldn't want your beneficiaries to get the money, pay estate taxes on it. If you live in New York and you could have a combined federal and New York estate tax of 49.9%, and now your kids are going to get clobbered with the estate taxes on that IRA money. And when they're taking the money out every year, whatever's left over, they're going to be paying income tax on it. Again, this is another reason to have a charitable entity as the beneficiary of it. You could do this in a variety of different ways. There are things called donor advised funds, right? And they're private foundations as well. So if you don't simply want to donate a certain dollar amount directly to a charitable entity, you can basically create a simple donor advised fund or a more complicated private foundation. Now, there are donor advised funds that are created by large entities like Fidelity. Fidelity has a charitable donor advised fund. That allows basically an immediate tax deduction of the money that you're placing in that donor advised fund. And you can basically, within the donor advised funds, select the types of charities that you want to get the money, right? Rather than, it could be one, it really can't be one charity, but it has to be a number of different charities, but you can select the charities that you want to be the beneficiaries of it. The fund advisor will take your recommendation to provide grants and distributions to any eligible IRC 501c3, IRS 501c3 entity, any charitable entity. So they'll take your advice and your recommendation when you're using a donor advised fund. You can always go out and create a private foundation, but that's much more expensive. It's much more legally complicated. It may allow you more control over the investments and allow you to employ certain members of your family to operate the private foundation, but there are a lot more regulations that need to be followed and more requirements when you have a private foundation rather than using a donor advised fund. Okay, So the use of these donor advised funds has been on the rise lately and is a very effective way of, getting IRA money to become a charitable deduction and also avoiding paying possibly estate taxes and income taxes on assets when you die. Okay. So again, that's the reason, reducing the potential for estate taxes. And we should know that right now, the federal exemption is $12,920,000 per person. It's both an estate and gift tax exemption. You could use up that federal exemption during your lifetime by making taxable gifts, right? Taxable gift would be any gift to any one person in any calendar year more than $17,000. That would be considered a taxable gift. So if I were to give Mark $100,000 this year and assume I don't have a spouse that can join in on the gift, of that 100,000, 17,000 would be tax-free. 83,000 would come off of my lifetime exemption of $12,920. Have to file a gift tax return. One thing that's important to remember is that this exemption, this large exemption for husband and wife, is going to become significantly smaller on December 31st, 2025, when the Trump tax cuts expire. That's the date the Trump tax cuts expire, and the almost $13 million federal estate and gift tax exemption becomes $6 million per person, right? New York has a much more onerous tax than federally. Again, to avoid the estate taxes, there are certain plan given methods that could lead to more assets being transferred to a non-charitable entity. In New York, which has much more onerous estate taxes, we put in for all our clients what we call a Santa Claus provision. Why is that? Because New York has an estate tax cliff. The exemption in 2023 for New York is $6,580,000 per person. In order to take advantage of that exemption, you have to have assets in your name alone when you die, right? So if you don't have anything in your name alone, it's all jointly held when you die, that exemption on the death of the first to die of a husband and wife will disappear. It's gone. Additionally, in New York, they have an estate tax cliff. If your estate is 5% greater than $6,580,000, which would be $6,909,000 or more, then you've gone over the cliff, and New York goes back to $1 and starts to tax you at a graduating rate, going up to a high of 16%. What we do is we put a clause in all the documents that says, if my estate is greater than the New York exemption, but it's not 5% greater, because there could be a significant estate tax, I give my executor, my trustee, the ability to give that money to a charity, right? To give that amount above the $6,580,000 to a charity to eliminate this tax on the difference between $6,580,000 and $6,909,000. So there's this tax. It could be very onerous within the gap between $6,580,000 and being 5% greater. And we put this clause, and it's called the Santa Claus provision in there. So, making those considerations, thinking of, reducing estate taxes, that's where the benefits of plan giving come in. They come in as advantageous for estate tax purposes and income tax purposes as well, especially if you don't have a large family and you have charitable inclinations. And that's really the important thing to remember. This is my contact information. And let's see, it's 205. And we're going to take gifts now for a few minutes. Is it 105? I'm sorry.
Sure.
Any questions?
Yes, thank you. Some have been sent into the chat, and some previously were submitted. I'm going to ask you some that I think are applicable, to a broad audience. Can you let's see. If no beneficiary is on the 401k, where does that as assets go?
It goes to your estate. If you don't have a named beneficiary on a 401k, an IRA, any retirement account, 403b, and there's no surviving beneficiary, then that money goes back to your estate could be subject to the claims of your creditors, including Medicaid, and would become a probate asset if you have a will, or an administration asset if you don't have a will. The pool trust, there's a question about that. The pool trust, basically the way that works, that's a way of sheltering income if you're going to be applying for Medicaid home care. It's not used in a Medicaid nursing home scenario. It can be used in other scenarios, but that's for another presentation. But generally, the pool trust comes very, very handy in protecting income of somebody that wants to stay at home, is eligible for Medicaid from a resource perspective, but has more income that's permitted. It allows you basically to keep a certain dollar of income right off the top, and then protect virtually almost all of the income above the amount that Medicaid allows you to keep, and allows that money to be used to pay your bills by enrolling in a pooled community trust. Some of the questions that we got before the program, the trust to protect the house to avoid nursing home cost. Are they irrevocable? Yes. Yeah, I mean, generally you use an irrevocable Medicaid asset protection trust. A revocable trust could work in protecting the house, but only in a very limited circumstance, right? So if, for example, I put my house in the trust and I was getting Medicaid home care and I died at home, right? The moment I die, that revocable living trust becomes irrevocable, and now Medicaid does not have a claim against it.
Mm.
But if I have the house in a revocable living trust and I have to go to a nursing home, and now I'm no longer in the house anymore, right? I have Medicaid can allege and can argue that I'm in permanent absent status. I've left the house for a period of 6 months or more, and now they can try to put a lien or a claim against the house that's in the revocable trust. So generally, the only time we use a revocable trust is where we have a client that is going to be staying at home and is in their 90s or in late 80s, and we don't want to create a 5-year look back period. How much should setting up a revocable trust cost? That's really hard to say, because that really depends on the planning that the individual's doing. Are we doing estate tax planning? Are we doing a revocable trust with a disclaimer trust? Are we going to have trust provisions for grandchildren in there? Is it going to be a lifetime trust? There's so many factors that go into the fee. I will tell you that we do estate planning on a flat fee basis. We don't do it on an hourly basis. And we generally reduce the fees depending on how many documents the clients are doing. So we treat them as packages. There's, package A, package B, depending on the documents you're going to do. Do a will or POA, it's the same thing. Again, it all depends on the complexity of the document. It's not based, at least from our perspective, it's not based on how much money you have. It's really based on the documents you're doing, how many documents you're doing, and how complicated are the documents. If you set up a trust in New York and then move to a different state, can you adjust or need to create new ones? Well, obviously, with a revocable living trust, you can always amend the trust. You can change the situs of the revocable trust to another state. In terms of an irrevocable trust, well, again, that depends on the nature of the trust. What kind of irrevocable? Is it a Medicaid asset protection trust? Is it a life insurance trust? What are the powers that are given to the trustees under the terms of the trust? So again, there are things that can be done. Generally, we do recommend that if you're living in another state for a lengthy period of time, that perhaps you do a will, power of attorney that complies with the requirements of that state, because those laws can be very tricky. For example, Florida has very unique rules about powers of attorney and what they control. So if you want a power of attorney to control real property in Florida, you actually have to identify the real property in the power of attorney. Thoughts on naming agents for a single person, no kids? Well, again, people you trust, right? If you have people, family members that you trust, you would look at those family members to be the agents. You wouldn't be looking for people that you don't trust. Again, maybe your mailman is not the best person to pick, to be the agent under your power of attorney, or the FedEx guy. You would want somebody you trust. And if you don't have somebody that you can trust to be the executor or trustee, then you would basically look, for example, at a bank, a financial institution, to be that has a trust department, to be the trustee. Some other questions that were in writing. My son is the beneficiary of my IRAs. Can he leave the accounts and investments in place? Well, he could leave them in the same financial institution and move the account into his name. However, under the Secure Act, he basically has those three options that I mentioned. Either take out all the money within 10 years, and you could do that in equal percentages over 10 years, take it out all in year 10, or take it out at the very beginning over 10 years, or at the end of the 10-year period. So you have those three options. Okay. What other question? Do you assist?
Here's one. Can that I thought was pretty good. Can you use an IRA to a donor advised fund? Can you use that
Yes.
benefit of IRA to a donor advised fund?
Yes. You can have the donor. Well, you can have the donor advised fund to be the beneficiary of the IRA, right? You can have them to be the beneficiary. I'm not sure about transferring an IRA into a donor advised fund.
No, not that.
No, I don't think that could be an issue tax wise, because you're changing the ownership of the IRA. But
I think they mean if you take it out and you want to do a qualified charitable distribution, can you do that to a donor advised fund? You can do it to PACE or was it?
Yes, exactly. You could do it to any entity that you want. Yes.
Okay, great.
As long as they're a 501c3 entity.
Yes.
Right.
Yeah. Okay.
What assets are excluded from an estate, not subject to estate taxes? Are IRAs with designated beneficiaries included in estate? Yes. IRAs, life insurance. If you're the owner of the IRA on your date of death, life insurance, if it's not owned by an irrevocable trust and you're the owner and insured, it's included in your estate at the time of your demise. Yes. They're included in your estate for estate tax purposes. That doesn't mean there's going to be an estate tax, right? Again, you're subject to having those limits, etc. For my aging parents, should we put their house in a trust? Well, yes. I mean, the answer is yes, because it's going to be a way of protecting the equity in the trust, right? They have this house, it's still in their names, and the equity is not protected. If they were to die and have the house in their name and they've received Medicaid benefits and they have a probate estate, you're going to have to do probate, and B, Medicaid's going to have a lien against the house for the value of services provided. Generally, the people that are not doing Medicaid planning are people that have more than $7, $8, $10 million worth of assets, because they're kind of self-insured, and they generally have, for example, an IRA with $2, $3 million, and that income from the IRA may be sufficient to pay for their living expenses in a home or home care, etc. So let's see, if an irrevocable trust was set up with specific real property as the only asset and the grantor did not have a will, does the residual estate or any other non-real property need to go through probate process? Well, if I have an irrevocable trust and I deeded my house to it or a piece of property to it, then when I die, that piece of property will be controlled by the terms of the trust. The trust would end and it would go to the beneficiaries under the terms of the trust. But if I die, and if I have other assets in my name alone when I die, could be real property or tangible or monies. When I die, whatever assets that are in my name alone and if I have a will, would have to go through probate. Yes.
Anthony, I think that just about is our time, but I want to certainly thank you. It's an amazing expertise that you bring here, and we really appreciate it. Just by the nature of your descriptions, it's a very complicated area, many of these things, and so one of the questions was, do you believe? What's your opinion of do-it-yourself websites and for wills and trusts? And I think clearly there's a lot of benefits of having an expert like Anthony Enea or your other provider. So thank you for that.
You're welcome. You're welcome. I'm not a big fan of those do-it-yourself will kits. It's very dangerous.
Yes,
It's dangerous in a lot of senses. Not only because the document may not be sufficiently adequate to deal with all the issues that you have in your state, but also it leads to the possibility of the document not being properly executed.
right,
And
right.
having issues that within the document that will raise the possibility, increase the possibility of the document being contested. Remember,
Yes,
a document that is executed under this supervision of an attorney has a presumption that it's a valid document. There is an inherent presumption that the document is valid because it was prepared and the execution was supervised by an attorney. When you're doing it yourself, you lose a lot of those presumptions. Okay. You may not
yes.
even, you may not do, for example, you may not know to do a self-proving affidavit, and you don't do a self-proving affidavit, or you have witnesses that are beneficiaries under the will,
Mhm.
or you have the notary be a family member that notarizes the signatures. There's so many problems that can have.
Yeah. So thank you again for that.
Yeah, that final question about must trustee live at primary residence to get the star
Sure.
exemption? Yes. That the house has to be the house that's in the trust that you're getting the star exemption for. Well, you have to live in that house. Yes. Right.
Okay. And so thank you to everybody else also for attending today. We look forward to seeing you at a future session, and we're planning a session for the spring semester. So we'll be in contact again soon to hear your ideas for that. Thank you very much to
Thank you.
everybody.
And everybody enjoy Thanksgiving, which is coming up soon. Have a happy Thanksgiving.
Excellent. Thank you.
Thank you.
Bye bye.
Bye, everybody.